The Subcommittee on Water and Power will come to order. I want to apologize to all concerned regarding the late start today. The consolation is there are no further votes scheduled, so there won't be any interruptions except from the members. So welcome to all of you. A quorum is present, and today the Water and Power Subcommittee meets to hear two bills, one of which protects valuable private water rights from efforts by the federal government to expropriate those rights through what should be a routine permitting process. The other bill reauthorizes the Emergency Drought Relief Act, which provides federal taxpayer dollars for local drought-related water projects. H.R. 3189, the Water Rights Protection Act, is a straightforward measure to prevent the U.S. Forest Service from demanding that privately owned ski resorts surrender long-held water rights under state law as a condition of receiving special use permits for long-standing uses of public land. Despite over 100 years of federal deference to state law, federal agencies have adopted the practice of demanding that water users transfer rights granted to them by states over to the federal government as a condition of getting a permit to operate on federal lands. This amounts to an uncompensated taking and is a violation of both the Fifth Amendment to the Constitution and a violation of state law under which the federal government must acquire water rights through the proper channels as would any other user. There are 121 ski areas on federal public lands, 14 of which, by the way, are on Forest Service lands in my district. These ski areas rely on privately held water rights for snowmaking, using this water as collateral for financing to build and maintain their facilities, and for supplying water to local communities that they support. In 2011, the Forest Service issued a directive that would effectively take these private property rights without compensation in violation of state law, while jeopardizing these enterprises altogether and all of the direct employment and spin-off economic activity and tax revenues that they provide. This action illustrates an increasingly hostile attitude by this agency towards those who make productive use of our vast natural forests, in this case by enhancing and attracting the tourism upon which our mountain communities depend. Although the principal victims of this policy have been our ski resorts, this subcommittee has also received reports of similar tactics directed against farm and ranch operations that rely on state-recognized water rights for irrigation and stock watering. Mr. Tipton's bill simply prohibits the federal government from using what should be a routine permitting process to extract long-held water rights from private users. This bill seeks to restore federal accountability and responsibility and gets the Forest Service out of what has been historically a state prerogative. We will also hear H.R. 3176, the Drought Relief Act offered by Mr. DeFazio. This measure reauthorizes a program that provides federal money for drought relief programs. Given the disappointing rainfall last year in many parts of the country, this is an important and timely subject. Of course, the whole purpose of federal water and power projects is to assure that there are ample supplies of water in times of drought. We will hear from the Competitive Enterprise Institute that natural processes produce some 45,000 gallons of fresh water each day for every man, woman, and child on the planet. The problem is that this abundant supply is unevenly distributed over both time and distance, which is the whole reason that we build dams and aqueducts in the first place. The more dams and aqueducts we have, the fewer water shortages we suffer. And the problem is we haven't been building a lot of these projects for quite some time for reasons that this subcommittee has often discussed. When we did build them, they were financed on the beneficiary pays principle, in which federal money fronted for these projects is repaid by the users of the water and power that these projects provide. I'm interested in knowing why that principle is not applicable here and whether our approach to drought relief ought to be aimed at producing permanent abundance rather than managing temporary shortages. It's certainly an important and timely discussion to have. Although the federal agencies are not here today, we look forward to getting their submitted testimony and answers to many questions for the record. For those that are here, I look forward to today's testimony on how we can protect state-recognized water rights and all of the many industries and uses that rely on them, and how we can better prepare for drought conditions to avoid needless expenditures of taxpayer dollars. And with that, I'm happy to yield to the ranking member, the gentlelady from California, Ms. Napolitano, for 5 minutes.
Thank you, you, Mr. Chairman, and good afternoon to everybody. Today's hearing focuses on the two bills that address important water issues in the West, H.R. 3176, the reauthorization of the Drought Relief Act, and H.R. 3189, the Water Rights Protection Act. And thank you to our witnesses for being with us even in the presence of this government shutdown. I am proud to co-sponsor H.R. 3176, legislation sponsored by my colleague, Ranking Member Peter DeFazio, which provides reclamation with the authority and flexibility to get water to entities, tribes who need it during drought times. Drought costs the U.S. economy between $6 to $8 billion annually, with 2012 drought costs possibly exceeding $35 billion. In 2013, almost 50% of our country is in moderate to severe drought. We will hear more of the effects of the drought in the West from the Western States Water Council witness. And may I add that many of the entities that are trying to figure out how to cope with the drought are not able to do it alone. We will also hear testimony that the federal government should not help the states during times of drought, that the federal government should not help, God help, California, home to the 5 most productive agricultural counties in the nation and the 8th largest economy with their water issues. The argument is California's problems are not the nation's problems. I beg to differ that. It's not that simple. What affects California affects the rest of the nation. That is why we are the United States of America. H.R. 3189, offered by Representative Tipton, is legislation that seeks to address an issue between Forest Service and the ski areas in his region. The ski areas are concerned about the Forest Service interim directive that requires the transfer of their water rights to the federal government. The Forest Service is concerned about their ability to manage the land if the ski resorts were to sell their rights. Legislation is so broadly written that it could apply to many actions on federal lands, not just the ski resorts. So we must be careful about how unintended consequences may affect some other folks. It is the responsibility of this committee to ensure proposed legislation receives the proper vetting. We did not receive agency testimony because of the shutdown. We don't have all the answers to the questions we have asked of the administration, again, because of the shutdown. Yet this hearing is moving forward, and it will be the only, and I repeat, the only opportunity for stakeholders to weigh in before markup. We're missing key information, but without the administration's position on these bills and our ability to question them directly. This is not the best way to do business, nor is it the best way to ensure that the legislation we pass serves the best interest of our taxpayers and our American public. The best way we can help our communities with their water challenges is to reopen the federal government, and we must focus on bringing government back to work so employees of not only the U.S. Geological Survey but other critical agencies can work and be participants and comment on our issues. Because of the government shutdown, only 43, and I repeat, only 43 people out of 8,623 USGS employees, that's less than half of 1%, are at work. We must bring back 3,311 of the 5,077 reclamation employees that have been furloughed and are waiting to go back to work for our country. Next year is expected to be a very dry water year, and we need them all back in their jobs to help plan for our future and to help our nation's not only economy but the rest of our nation. It is ironic, though, that it takes the absence of these employees to value their presence. They're essential to this country and to the legislative process, and we need them back at work. As we consider these important pieces of legislation, we must first prioritize reopening government. We must vote on a clean resolution, continuing resolution, with no add-ons, and I mean none. Clean. Open the federal government and put people back to work. Let us work for our citizens, because that's what they sent us here to do. And Mr. Chairman, I'd like to, for the record, put 3 letters of support from the Family Farm Alliance, from the Association of California Water Agencies, and from the Western States Water Council, associated with Western Government Association.
Without objection.
And my last plea is that I would respectfully request that we wait to move any of these bills until government is open and we can hear from the agency that is supposed to be here. Thank you, Mr. Chair, and I yield back.
Thank you. And before we proceed, the chair would ask unanimous consent that Mr. Bishop of Utah and Mr. Amadei of Nevada be allowed to sit up with the subcommittee and participate in the hearing. Hearing no objection, so ordered. It is customary for us to recognize any other members who wish to make opening statements, and the chair is now pleased to recognize Mr. Tipton of Colorado for 5 minutes.
Thank you, Chairman McClintock, for convening today's hearing, and thank you for your support and engagement in working with me on this critical issue. I'd also like to thank Mr. Bishop, Mr. Amade, Ms. Loomis, Mr. Gosar, Mr. Simpson, Mr. Kaufman, and Mr. Polis, who've all joined in this bipartisan effort and continue to work with me to safeguard Western water rights. Finally, I want to thank David Corbett and Glenn Porzak from Colorado and Randy Parker from Utah for making the trip to D.C. to be able to testify on behalf of the Water Rights Protection Act. Recent federal attempts to manipulate federal permit, lease, and land management process to circumvent long-established state water law and hijack privately held water rights have sounded the alarm for all non-federal water users that rely on these water rights for their livelihood. The most recent case of the federal government's overreach and infringement on private property rights, which we will discuss today in the hearing, involves the U.S. Forest Service attempt to require the transfer of privately held water rights to the federal government as a permit condition on our National Forest System lands. There is no compensation for the transfer of these privately held water rights, despite the fact that many stakeholders have invested millions of their own capital in developing them. This Forest Service permit condition has already hurt a number of stakeholders in my home state of Colorado, including the Powderhorn Ski Area in Grand Junction and the Breckenridge Ski Area Resort. Despite having been excellent stewards of the environment and their water rights, the Forest Service has demanded the relinquishment of state-granted water rights from these ski areas in order to continue their operations. These same nefarious tactics have been used in Utah, Nevada, and other western states where agencies have required surrender of possession of water rights in exchange for approving the conditional use of grazing allotments. This federal water grab has broad implications that have begun to extend beyond recreation and the farming and ranching community and are now threatening municipalities and other businesses. To add insult to injury, the Forest Service claims remarkably with a straight face that it's implementing these federal agency permit conditions to prevent water rights from being sold off and or used improperly. However, according to the Chief Forest Service Officer, Tom Tidwell, comments made in this very committee, there have never been any cases where privately held rights have been used improperly. Furthermore, the language of the Forest Service's water clause offers no guarantee that the Forest Service could not divert water to other locations or direct water for other purposes altogether. As a result of the efforts that began in October of 2011 and encompassed testimony from several hearings, conversations, and with numerous stakeholders across Colorado and the West, close collaboration with my friends on this committee, I introduced the Bipartisan Water Rights Protection Act. This legislation provides critical protection for water rights and holders from federal takings by ensuring that the federal government agencies cannot extort private property rights through uneven-handed negotiations. The Water Rights Protection Act offers a sensible approach that preserves water rights and the ability to be able to develop water requisite to living in the arid West. This is without interfering with water allocations for non-federal parties or allocations that protect the environment cherished by all Westerners. As could be expected of the West-wide legislation that seeks to protect all water users from the relentless efforts of the federal government to extort non-federal water rights, this bill is a work in progress. I look forward to continuing to work with my colleagues from other western states to ensure that no state-recognized water right goes unprotected from the class actions this bill prohibits. To this end, the brief two-page bill prohibits federal agencies from pilfering water rights through the use of permits, leases, and other land management arrangements, which would otherwise have to pay just compensation under the Fifth Amendment of the Constitution. The bill also prohibits federal land management agencies from forcing water users to apply or acquire rights for the United States rather than for the water users themselves. Finally, this common sense legislation provides certainty by upholding the long-standing federal deference to state water law on which countless water users rely. The Water Rights Protection Act has already received endorsements of the National Ski Area Association, the Colorado Water Congress, Colorado Ski Country, USA, the Associated Governments of Northwest Colorado, the American Farm Bureau, the National Cattlemen's Beef Association, the Family Farm Alliance, the Public Lands Council, the Colorado River Water Conservation District, and the Pacific Northwest Ski Area Association, and the California Ski Area Association as well. Mr. Chairman, I would like to be able to submit for the congressional record their letters of support.
Without objection.
Thank you, Mr. Chairman. And further, we just received a letter of support that came in from the Family Farm Alliance for the record as well. Their testimony supports my bill and indicates that more water storage is a long-term solution to the drought.
Also without objection.
My hope is that today's hearing will further strengthen the bipartisan efforts to be able to protect local water rights from the federal government and their overreach and takings. I appreciate the opportunity to discuss this important legislation, and I, along with the ranking member, do look forward to the federal government trying to justify taking Western water rights. With that, Mr. Chairman, I yield back.
Great, thank you. The chair is now pleased to recognize Mr. DeFazio for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, thanks for the hearing today on 3176. I appreciate it being put on the agenda. I want to thank the Western States Water Council for coming to D.C. to testify, especially at this odd time of government shutdown. It does two simple things. It reauthorizes the 1991 Reclamation States Emergency Act for an additional 5 years till 2018. It gives BUREC the flexibility to expedite water transfers between projects, move non-project water on federal facilities, construct temporary structures and wells during times of drought. These are not long-term solutions, but they are sometimes required to mitigate, these episodic events of drought. It also authorizes reclamation to assist in drought contingency planning with all 50 states, tribes, and territories. Drought Relief Act by no means, a solution, a total solution, but I believe it is an authority that's vital to BUREC when they're turned to as a last resort in times of emergency. But the second authority here, drought contingency planning, could also go to some of the issues raised earlier about storage and other things. Secondly, we're hearing 3189. Obviously, whenever you begin to discuss water rights and water law in the West, it's incredibly emotional. It's something that is unbelievably complicated within and across state borders, and not easily understood. I don't know what the Forest Service was attempting to do in its first directive, which I believe was overly broad and didn't seem to distinguish between water rights, which might be actual existing within the leasehold or the ski area itself that pertain to the federal land, or those which were acquired from off-site by the operator. It was thrown out by the courts mostly on procedural grounds, but I think in the interim they did hear concerns. They were in the process of developing a new directive, which unfortunately we won't be able to hear about today. And it was supposed to come out next month for a period of public comment, and that probably will be allowed. I look forward to an opportunity to have that discussion. I'm concerned that the legislation is drafted would seem to go far beyond protecting the rights of the ski operators, who are probably the object of this unknown new directive, but we don't know that exactly either. But it applies to all actions requiring a permit on federal lands. What does that mean for grazing? I don't quite understand the full implications of that. What would it mean for oil and gas development? Fracking takes a lot of water. There are some very serious issues there. There's fracking, a tremendous amount of fracking on private land, but there's also applications pending and areas of federal land. So I think it could go very, very far beyond and have unintended consequences, given the way it's broadly written. I appreciate that the author said it was a work in progress, and I think there are legitimate rights to be protected here and want to work to protect those, but don't want to overreach either. So hopefully we won't move forward until we have an opportunity with a restored government to have the Forest Service come in and explain its new directive, and see if that doesn't do what we think it needs to do, then take more targeted action. Thank you, Mr. Chairman.
Thank you. The chair is now pleased to recognize Mr. Gosar for 5 minutes.
Thank you, Chairman McClintock, for holding today's hearing, and to my friend, Congressman Scott Tipton, for introducing this important legislation. In the West, we have a saying, whiskey's for drinking, water's for fighting over. And nowhere is that more true than the state of Arizona. In Arizona, water means life. The majority of my state would be an underpopulated desert without the forward thinking of leaders when it comes to water policy. Those leaders recognize that Arizona faces constraints on its water supply more severe than almost any other state in the nation, and took careful, proactive precautions to protect and manage our water resources. In fact, before Arizona even became a state, the territorial legislature adopted the 1864 Howell Code that established our prior appropriations doctrine over surface water rights. The pursuit of water enabled a small state of ranchers, miners, and farmers to take off economically and become the beautiful, diverse place to live in today. And the century-long battles over our natural resources, in particular water rights, had an integral role in formulating our state's political landscape. Today, Arizona is a very independent state, politically shaped by people of all walks of life who have valued states' rights and self-determination. That is why this bill we are considering today is so important. Arizona has one of the most, if not the most intricate state water law in our country. The right to water is a carefully guarded property right held at a higher value than a person's home or material possessions. So the notion that the government can come in and hold permits, leases, and rights of way hostage in efforts to get a private entity to forfeit its private property rights, its water right, is downright offensive. And that is exactly what the United States Forest Service is currently doing. Under a 2011 directive pertaining to ski area special use permits, the Forest Service is trying to require an applicant for a permit to relinquish privately held water rights to the federal government as a permit condition. There is no compensation for this transfer of rights, even though our constituents or their descendants have spent major portions of their lives and their money to develop these rights. This is an egregious policy that must be stopped and is a violation of our state sovereignty and individual property rights. In rural Arizona, our economy is heavily reliant on activities on federal lands, including the Northern Arizona Ski Area, Arizona Snow Bowl, our mines, our ranches, and our agricultural production. These industries are the bedrock of Arizona's 5 Cs and our economic viability, and the Forest Service's policies could bring all of these important economic drivers to a halt. My friend Congressman Tipton's legislation, the Water Rights Protection Act, shields our constituents from this kind of federal regulatory water grab and upholds our state's sovereignty to protect its water interest. I strongly support these goals. In fact, I see fighting for these goals as my obligation as one of Arizona's rural representatives to the federal government. I look forward to working with some of the experts on the ground in Arizona and with Scott to make sure to ensure that no state recognized water rights goes unprotected from the class of actions this bill prohibits. Ultimately, I look forward to helping the bill's sponsors quickly advance this bipartisan legislation. Its enactment is critical to reasserting state sovereignty over water rights and the economic viability of our western communities. I look forward to hearing from the witnesses, and I yield back the balance of my time. Thank you.
Thank you. The chair is now pleased to recognize the gentleman from California, Mr. Costa, for 5 minutes.
Thank you very much, Mr. Chairman. For the purposes of my opening comments, I will direct them to the DeFazio bill as it relates to drought relief. And I think it's important that this subcommittee at the time consider the benefits that have accrued over the years when we've had to deal with states, particularly western states, that have dealt with the challenges of drought conditions that we know are cyclical as we look at over 100 years of recorded weather history. And the fact is that the drought relief assistance from the federal level has made a difference. I'm looking at a series of printouts that indicate from 2007 to 2012, from Arizona to Utah, to states that have benefited from drought relief assistance by the federal government. I think it's important that we continue to provide support. Obviously, the states have their own sovereignty as it relates to many of the water issues that are in their jurisdiction. However, the fact is that we know that where water flows food grows. And it is an absolute essential key resource as it relates to our urban populations as well. So there is a hand-in-glove relationship between our water resources in America, and nowhere is that felt greater than in western states because of the arid conditions, of course. The fact is, most of our infrastructure that has been developed for water in the West is aging. It varies in length, but some of it is over 100 years old. If it were not for the development of that water resource when the West was being developed, we would not have the ability to provide the multiple various economies that exist in our western states. I am very worried. I'm very worried that we are treating water as we are treating many of the other issues around here, i.e. a political football. We can have differences, but the fact of the matter is we must invest in our water infrastructure. We know that the climate is changing. I don't care whether folks want to just discern that man has a limited role in that. I think that's subject to debate. But the fact is the weather has been changing for millions and millions of years. You just look at the tree ring studies done in the sequoias in the Sierra Nevada mountains, where over the last 1,000 years, because these trees are as old as 2,000 years old and older in some cases, where they can determine cycles that have occurred between the narrowness of the rings of the trees between wet cycles and dry cycles. So the fact is, weather is changing. It will always continue to change. And if in fact the weather patterns continue to change, our water systems may be inadequate to deal with our future needs. They are inadequate to deal with California's current needs. We have a water system that was designed for 20 million people. Today we have 38 million people. By the year 2030, we will have 50 million people. And the fact is we are not making the same kind of common sense solutions that our parents and our grandparents did generations ago. So obviously I will be speaking in support when we get to the DeFazio measure on how we can continue to support efforts by states that have benefited from this drought relief assistance. And I look forward to continuing to working with all of my colleagues on a bipartisan basis, because that's the only way we ever get anything done in this place. Thank you very much, Mr. Chairman.
Chair is pleased to recognize Mr. Amadei for an opening statement.
Thank you, Mr. Chairman, and I want to thank my colleague from Colorado for introducing this measure. In the short time that I've been here, this has come up several times, and I think it's important to note, as it always is, what the bill actually says. It talks about requiring transfer. Nothing in the legislation says, please ignore water issues when you're making permitting decisions. They are legitimate things to be considered as you make any land use permit. The part that necessitates this bill, in my experience, is this. On multiple occasions, you have had federal land management officials not consult the state water administrator, state water engineer, whatever they're called in your particular district. They have usurped that authority completely and said, I have groundwater concerns and therefore I am conditioning your permit or I am denying it, without ever talking to the individual who under state law has exclusive authority to adjudicate those matters. And those matters, that is an important first part, because those matters, if you don't like the way they adjudicate them, you have administrative processes, you have judicial processes, you have due process for addressing that. In a federal permitting context, if you usurp that state engineer's authority without ever even really talking to him, then what you have left is almost nothing. And so it's not ignore groundwater issues, it's please go to the person who has jurisdiction. And then we move to the second part, which the bill does say, on multiple occasions where in violation of the law in my state, and by the way, it's not much different from the ranking member, all western states, it is a large amount of surface area that the federal government owns. That's the fact. No sense lamenting it or whatever. We can talk about what to do about that. But the fact is you own a large amount, and really, you need to own the water rights too to have control over it when you control the surface area. So when you tell somebody in the agricultural industry, when there's a state law in my state that says you cannot hold stock water, groundwater rights unless you own stock, and the Forest Service says we don't own stock, but we want to condition a permit on you issuing your stock water permit to the Forest Service, it is a condition for a federal permit which is in black letter law violation of state law. And when you say, what are you doing? Well, we kind of think we have authority under NEPA to do that. Could you please point that out? We just think we do for supposition, for this connection, for that connection. And the idea is not to bash those folks, but it's to say, you really don't have the authority to do that? What an ultimate act of hypocrisy to condition a federal permit on violation of a state water law for which you really don't have that. I want to make two more points, though, because if it's really about the resource, in my state, the federal government can hold water rights. Just comply with state law and you can be issued. So it's not you can't have them. But this thing where you skip the state engineer and do your own basically no due process to rule on state water law, or you require an absolute violation of state law for a federal permit is not good business, and I join with my colleagues both from California. That is not good business regardless of what side of the fence you're on. So I want to give a shout out to my colleague from Colorado, and the drafting of this is actually very, very elegant in terms of, my God, it's a page long, and just says, hey, play by the state rules on water issues. If the BLM or the Forest Service have a concern about groundwater, then go talk to the state engineer, and whatever he or she says is what everybody lives with. But do not ignore the state engineer and bring those duties onto yourself. So with that, Mr. Chairman, I appreciate the opportunity to participate today and the courtesies the subcommittees extended me, and I yield my remaining time to my colleague from Utah.
Thank you, Mr. Amadei. I appreciate that. I want to say two things very quickly. Number one is I appreciate the committee holding a hearing on these bills, very good bills, and I'm co-sponsor of one of them, and I appreciate the leadership of that. Number two, I want to specifically recognize and welcome Randy Parker from the state of Utah, Utah Farm Breeders Association, here as one of the witnesses. He understands the significance of water as it relates to agriculture and ranching in our areas and how important it is. Obviously, it cannot be done without water rights. I mean, there's a cliche we have in Utah that it is more important, it would be far better to be head of the ditch than it would be head of the church. That's one of the issues that we have at hand here, and I appreciate his comments on this. He will explain why it is so significant to maintain water rights that have traditionally been there as these people have entered into these operations and guarantee that they are maintained. And so I appreciate his willingness to be here. I appreciate your willingness to indulge me as part of this committee. I came in late, so I'll make up for that by leaving early because I have another committee right now, and this does not give Mr. Costa and others and Ms. Napolitano a chance to abuse me if I leave, so I think that would probably be the best thing I could possibly do. But I do want to thank you for inviting Mr. Parker and inviting me to be part of this committee.
Well, here's your hat. What's your hurry? Mr. Bishop actually is entitled to another 4.5 minutes on his own.
To which I will yield back for everything else.
Well, the committee always appreciates the dramatic exit. Just for the record, the chair wants to allay the concerns that were expressed earlier regarding the shutdown and the absence of the U.S. Forest Service. U.S. Forest Service actually informed the subcommittee before the shutdown that they could not appear on the Tipton bill, would not discuss it. Their new directives being reviewed by the OMB, and they said they can't talk about it until the review is done and the directive is out for public comment. So the shutdown does not affect the Forest Service's willingness to be here today. They were not willing to be here anyway. With that, and if there are no other opening statements by committee members, the chair is pleased to welcome our panel of witnesses and once again to thank them for their patience and indulgence. Each witness's written testimony will appear in the full hearing record, so I'd ask that keep your comments down to 5 minutes. The timing lights are pretty simple. Green, you've got all the time in the world. Yellow is 1 minute. Red means that you're out of time and out of attention of the membership. I think there was a study done some time ago that indicates that 5 minutes is about the maximum attention span of a member of Congress. So keep that in mind when that red light goes off. And with that, the chair is pleased to welcome our first witness today, Mr. David Corbin, Vice President for Planning and Development at Aspen Skiing Company from Aspen, Colorado, to testify.
Oh, there we go. Thank you, Mr. Chairman. I understand the limitation on time, and we'll try to briefly summarize the comments. Still can't hear? I'm sorry. My name is David Corbin. I'm Vice President of Planning and Development for Aspen Skiing Company. We're a ski area operator and hospitality company located in Aspen, Colorado. Personally, I have 25 years experience in the ski industry, working first with Vail Resorts, and for the past 8 years I've been with Aspen Skiing Company. I've had the privilege of working in the industry from Lake Tahoe to the Central Rockies to the White Mountains of New Hampshire, and worked on federal lands in all of those locations at some point or another. Aspen Skiing Company owns 4 ski areas. We have 4 special use permits. We employ about 3,400 people locally in peak season, and we host 1.4 million skier visits in Aspen, again, on the public lands. We are members of Colorado Ski Country, and we are likewise members of the National Ski Areas Association. The National Ski Areas Association is essentially our national body that represents our interests as an industry before Congress and other public agencies, and performs a variety of activities on our behalf, but represents 121 different ski areas across the country who operate on the public lands. We very much support, and by we I mean Aspen Skiing Company, Colorado Ski Country, and NSAA, very much support this bill, and thank Congressman Tipton and Polis in particular as Colorado representatives and sponsors, as well as the other sponsors. We believe the Water Rights Protection Act is very much essential to our business and protects our business interests in ways that we appreciate a great deal. We value and respect our partnership with the U.S. Forest Service. We indeed work quite closely with them. I regard my White River Forest Supervisor as a very close colleague personally and professionally. We likewise believe that we are very capable and intelligent stewards of the land, and work quite carefully to protect the environmental standards that this country aspires to. In the course of that, we likewise think that water is an absolutely essential element to our business. And in response to one of the comments I heard before, we do not get any water with our special use permits. When a special use permit comes to us, the federal government hasn't given us additional water in the course of issuing that permit. We go out and acquire it. We buy it, we procure it, we go ahead and buy it from other providers as well. We look to Congress to provide some assistance. Indeed, the agency is in the process of promulgating rules and has proposed rules before. We believe this bill is very helpful in guiding or steering the agency towards what we believe would be more prudent rules and regs. We very much like the bill in the sense that it does not require us to transfer those separate water rights that we have purchased and developed and built infrastructure for on our own. We like the fact that there would be a prohibition against such a compulsory transfer, which we very much think is a taking, and we would hope the Congress would likewise see it that way and help and support us in that regard. Ourselves, we use a fair amount of water, 200 to 250 million gallons a year in snowmaking. That is essential to us. Snowmaking essentially provides the base for us to begin and completes our season. And for our purposes, we cannot see those rights evaporate or be lost, as it would severely jeopardize our ability to operate, and it would likewise financially subject us to very difficult circumstances, because we need both Christmas season and end of season to essentially make our economics work. So to lose snowmaking and to lose the water associated with it would very much jeopardize our operations and our continued financial viability. We hope that you would take our testimony, written as it is before you, into account, and I very much appreciate the opportunity to speak to you today. Thank you.
Thank you very much for your testimony. The chair is now pleased to recognize Mr. Randy Parker, the CEO of the Utah Farm Bureau Federation from Sandy, Utah, to testify.
Thank you, Mr. Chairman, ranking member, and committee members. Thank you for the opportunity to be here. My name is Randy Parker. I am CEO of the Utah Farm Bureau Federation. I'm here today representing more than 28,000 member families in Utah and more than 6 million families who are members of the American Farm Bureau. Through our grassroots process, Farm Bureau provides policymakers with recommendations on water in Utah and in the western public land states. Farm Bureau is concerned with the federal government expanding its reach and control over Utah and its natural resources. Utah farmers and ranchers want federal agencies to honor state water law and to not claim ownership of water developed on public lands. Utah Farm Bureau supports H.R. 3189 because it recognizes the state's sovereign water rights and protects livestock water rights from illegal federal claims and takings. The American Farm Bureau policy calls on Congress to dispel uncertainty. The Intermountain region of the U.S. Forest Service has filed more than 16,000 diligence claims on forest system lands in Utah, challenging ownership and increasing uncertainty. The agency says its claims are based on federal ownership of the land and water the ranchers used prior to Congress granting Utah statehood. Couldn't that be argued to be the same in every state in the Union? American Farm Bureau opposes any preemption of state law, pointing out water rights as property rights cannot be taken without just compensation and due process of law. Farm Bureau supports H.R. 31, the Water Rights Protection Act, because it is designed to dispel uncertainty and recognizes state sovereignty and historic water law. In addition, it underscores the constitutional protections of just compensation and due process of law. To illustrate the need to protect livestock water rights, the experience of the Tooele County, Utah Grazing Association is instructive. In the spring of 2012, ranchers were presented with a packet from the Forest Service that requested that they sign a change of use application. Change applications allow the Forest Service to change use of the water from livestock to other uses as determined by the agency. The ranchers were told if they did not comply, it could adversely affect their turnout onto their forest grazing allotment. The ranchers were not only concerned how the action impacted their water rights, but how it would impact cattle grazing on those allotments into the future. The Forest Service protested, suggesting the request was in error and that they were only asking ranchers to sign a joint ownership agreement. In either case, signing change of use application or agreeing to a certificate of joint ownership, the federal agency is seeking a relinquishment either in whole or in part as a condition of access to the grazing allotment. In Tooele County, Utah, or anywhere across the Utah landscape where livestock graze on the public lands and use the state's water, it is the economic driver for our rural communities. Livestock production is the economic engine of Utah's rural cities and towns. Passage of H.R. 3189 will build rural communities by providing certainty, not by seizing assets through relinquishment or diminishment of livestock water rights. Livestock water is available in stock water troughs, in guzzlers, in seeps, and in small streams scattered across Utah's backcountry. It benefits not only sheep and cattle, but wildlife like sage grouse, deer and elk, and even threatened and endangered species like the Utah prairie dog. Utah has joined other western states like Idaho and Nevada in protecting historic livestock water rights and limiting federal ownership. Utah's Livestock Water Right Act defined the beneficial user as the owner of the grazing permit. The Forest Service seized on that opportunity, filing on livestock water rights on every active allotment in Utah, claiming they are the owner of the grazing permit. In closing, it is important to note that the Utah Livestock Water Rights Act makes livestock water rights pertinent to the grazing allotment on which the livestock is watered. It provides certainty to ranchers and underscores our commitment to rural Utah that grazing will continue on the public lands. This commitment and H.R. 3189 provides greater certainty to ranchers and the future of public land grazing than the assurances of federal bureaucrats and being at the whims of our fickle legal system. Thank you, Mr. Chairman. I look forward to questions.
Thank you, Mr. Parker. The chair is now pleased to recognize Mr. Glenn Porzak, attorney for the National Ski Area Association from Boulder, Colorado, to testify. Welcome.
Thank you very much. I appreciate the opportunity to testify today in support of H.R. 3189. I'm here principally on behalf of the National Ski Areas Association, but also here on behalf of the Eagle River Water and Sanitation District and the Upper Eagle Regional Water Authority. With regard to the National Ski Area Association, as has been mentioned, it has 121 members that operate under Forest Service lands, and that constitutes the majority of the ski area visits in the United States, and they're located in 13 separate states. Those ski areas generate over $12.2 billion in annual revenue. With regard to the Eagle River Water and Sanitation District and the Upper Eagle Regional Water Authority, they serve the over 60,000 people from the areas of Vail to Wolcott. That spans the congressional districts of both Congressman Tipton and Congressman Polis. And they're the second largest municipal water supplier on the western slope of Colorado. The ski industry, has been mentioned, literally spends collectively hundreds of millions of dollars on the water rights that they use for their various operations. They're valuable assets to the ski area owners, and that water is absolutely crucial to their operations and their future growth. In turn, those operations and that future growth, it directly impacts the rural and mountain economies in which those ski resorts operate. They employ over 160,000 people in those rural and mountain environments, and their economies as well depend on that investment in the water. If there's not enough water for the snowmaking, for the domestic uses, then you're going to see a major impact to the resort communities that are in the vicinity of those ski areas. One of the important points that I want to make is that we talk in terms of the fact that this is a ski area issue. It's far more than a ski area issue. In the course of the original litigation over the first water right directive that was issued, it was discovered that not only is there a directive issued specifically at the ski areas, but there are other directives that are issued at municipal water providers, the grazing industry, and others. This is an issue, and indeed the legislation proposed would prevent the taking of water rights, not just for of the ski areas, but also the municipalities and the grazers and other resort communities, and that's an important thing to keep in mind. That there's a system-wide impact, if you will, that we believe violate not only the Fifth Amendment of the U.S. Constitution, but also the congressional authorization that the Forest Service has. And that's the next point that I want to make, is that Congress has not delegated the authority to the Forest Service to use its federal land use power to seize water rights owned by non-federal entities. Whether you look to the Federal Land Policy and Management Act, to the National Forest Management Act, or any other of the organic acts, they defer to state law. and make it clear that the Forest Service does not have the authority to take water rights under their land use authorities. Last point is that this is not a new issue. Over 20 years ago, this effort was attempted by the Forest Service, and as a result of that, Congress formed the Federal Water Rights Task Force, and it issued a report in August of 1997, and I'll just quote from that: Congress has not delegated to the Forest Service the authority necessary to allow it to require that water users relinquish a part of their existing water supply or transfer their water rights to the United States as a condition of the grant or renewal of the federal permits. Thank you very much, and I look forward to answering any questions you may have.
Thank you, Mr. Porzak. The chair is now pleased to recognize Mr. Tony Willardson of the Western States Water Council based in Murray, Utah, to testify.
Thank you, Mr. Chairman, and Representative Napolitano and the other members of the subcommittee. The council is an advisory body to the Western governors, and our members are appointed by the governors and represent senior water managers and administrators. It's actually a little ironic that I'm here after being in snowed-in South Dakota for 3 days, that I'm here to talk about drought. And I spent 3 days in a hotel with a good friend of Mr. Amadei's, Mr. Roland Westergaard, who is a member of the council. My testimony is based on a position which is included for your review. And as part of that, I would also like to recognize that part of this act authorizes the Secretary to work with other federal and state agencies in providing hydrologic data collection and water supply forecasting. And before you, I believe you have a brochure which talks about another program that we support, the National Integrated Drought Information System, which includes the support of the Department of Interior. Drought has been and continues to be serious in the West. This is an October 1 diagram of the extent of the drought. While there has been some alleviation, there is still most of the West that is afflicted by moderate to extreme drought, with a few exceptions where there is still, with a few areas that there is still exceptional drought. The NOAA has determined that 3 of the 5 most costly weather-related disasters, including Katrina and Superstorm Sandy, the other 3 are drought. We're still calculating the costs of the drought last year. Actually, it was record-breaking and compares only to the drought of 1934 in terms of its persistence and magnitude. It's also unusual in its quick onset and was become known as a flash drought. And it will be some time before we can fully calculate all of the costs. But that highlights the need to focus resources on planning for and mitigating drought impacts. These antecedent conditions we anticipate will mean that drought will be with us for some time, with continuing impacts on the economy, the environment, and other interests. As was mentioned by Representative Napolitano, it estimates that drought costs $6 to $8 billion a year in the United States. Here to the ski industry last year, estimated that skier visits were down nearly 12% in 2012 compared to 2011. 70% of the nation's crop and livestock production was affected last year. There was over $1 billion in damages due to wildfire, and the Colorado River experienced its driest year since records began in 1985, with only 44% of the average annual runoff. But notwithstanding the severity, we also have to take, in the past we've taken a reactive approach and to responding to drought on an ad hoc basis, and we need to be much more proactive. In 1996, the Western governors set a goal of being an aggressive goal of changing the way that we deal with drought and responding to drought in preparation and being more prepared. And we've worked with a number of federal agencies, including the Bureau of Reclamation, to improve our management. 1 out of every 5 farmers in the West is served by the Bureau of Reclamation, along with 31 million people. And they have a very important role to continue to play in water supply management and reliability in the West. I'd mention, too, that with respect to the assistance that they provide under the Act, the authorities that are unique, they have the ability to participate in drought banks as well as to acquire water from willing buyers and facilitate trades between buyers and sellers. To provide water under temporary contracts and also make reclamation facilities available for the storage and conveyance of both project and non-project water, as well as to acquire water for fish and wildlife. With respect to planning, Benjamin Franklin said, by failing to plan, you're preparing to fail. And the planning aspects of this bill are also important. States have primary authority over the allocation of use of water, and I want to emphasize that. But we've long supported integrated water resources management and planning and the need for comprehensive response to drought. And I just conclude by saying that with the exceptional drought conditions that we have, and absent reauthorization of this bill, it will be even more difficult to address many of the challenges that we face. And there will be serious consequences for small communities, for tribes, and others who do not have the resources that are available to them in assistance through this act. Thank you very much, Mr. Chairman.
Great. Thank you for your testimony, and the chair is now pleased to recognize Mr. Wayne Cruz, Vice President for Policy and Director of Technology Studies for the Competitive Enterprise Institute based in Washington, D.C. to testify. Welcome to the committee.
Hi, I am Wayne Cruz, Vice President for Policy at CEI, and I thank the committee for the invitation to address federal drought relief funding and planning. I come at this issue from the perspective of one who spends most time on tech and frontier policy issues, industry policy issues, including compiling an annual federal regulation report called 10,000 Commandments. Given environmental barriers to urgently needed water in the West, I completely understand the desire for the funding in H.R. 3176, and granted, the dollars sought are trivial in context of the current budget battles. But I caution against any fostering of any further declaration of dependence on federal dollars in any sector. The regulatory reforms and infrastructure liberalization actually needed for plentiful, adaptable, environmentally conscious Western water should dominate our attention. The good news is water is not getting more scarce overall. It's an earthly constant. The bad news is we artificially interrupt access to water, so management and allocation of that constant supply does matter. The Western and California natural environment is a world wonder, but so too is the remarkable man-made infrastructure. Western environments are some of the most altered on Earth, and yet environmental protection is not alien to providing plentiful water. The opposite is true. Restraints like waste stream recapture, conservation and stewardship, property rights regimes, liability and insurance all must evolve alongside infrastructure. Governments often magnify environmental damage and risks. Water resources and environmental amenities should be better integrated into the property rights wealth-creating sector, an evolution long since derailed not just here, but elsewhere like in electromagnetic spectrum, electricity, and transportation grids. Instead of the Drought Reclamation Act, I advocate increasing separation of water and state. We should lessen having government steer while the market merely rows. Federal policies can be contradictory, too. We hear a lot about a federal infrastructure bank, and we're endlessly regaled about the urgency of bolstering critical infrastructure. But these sentiments are certainly undercut by onerous permitting and environmental regulations that aggravate drought out west. The fact is, as a free society becomes wealthier, cross-industry creation of infrastructure like water should become easier, not harder. The vastly poorer America of 100 years ago built overlapping, redundant infrastructure. So if we can't do it today, it's largely because of man-made policies, not genuine drought. Infrastructure can take many forms, but all around better reservoir storage, pipelines and canals, trucking and transport, and crude oil carriers can aid supply and lessen artificial drought and lessen impetus for federal funding. So too can improve trade between cities, farmers, and private conservation campaigns. Improving water infrastructure can also reduce the waste that now depletes some 17% of annual supply, as noted in a Competitive Enterprise Institute by Bonner Cohen last year. All this can supplement direct sourcing alternatives, including drilling, gray and wastewater treatment and reclamation, stormwater harvesting and surface storage, and even desalination where it's economically rational. When linking investment to human needs, private investors can test low probability projects, counting on rare successes to offset the failures. Markets need to be good at killing bad projects. As CEI's founder, Fred Smith, puts it, instead of trying to improve speeds by picking particular horses to run on the economic racetrack, we must improve the track itself so all the horses can go faster. And letting jockeys keep more of their earnings means more jobs in these suffering areas too. Thus, we need sweeping regulatory liberalization also. In my written testimony, I cover reform options to enable a private sector flush with research and development cash and investment cash to dwarf H.R. 3176. Finally, this is the Water and Power Subcommittee, and I think it's vital to step back and explore dismantling these regulatory silos that artificially separate our great network industries like water, electricity, transportation, and telecommunications. Leaving antique 19th and 20th century infrastructure regulation intact hampers 21st century investment. Our primary challenge is to integrate modern water resources further into the market process and the sophisticated property rights and capital market systems of the modern world. Despite everything, gallons cost less than a penny, and yes, even fill swimming pools and quench lawns in deserts. The last time I spoke in the subcommittee, I was asked if I thought access to water was a right. Now, committee members who believe it is must consider the full implications of that question. What makes abundant water the most critical of critical infrastructures possible? Thank you.
I want to thank all of the witnesses for their testimony. We'll now go to questions by the members. Each member will have 5 minutes and may be submitting additional questions if they can't get all of them in during the constraints on the time. Chair will begin, and I'd like to begin with the Tipton bill. Mr. Corbin, Mr. Parker, and Mr. Porzak, each of you have highlighted attempts by the administration to expropriate water rights that are recognized under state law by various types of water users. Heavenly Mountain Resort near Lake Tahoe in my district employs about 1,215 people. The jobs are contingent on the availability of millions of gallons of water annually that are held by the ski area to make snow. I know the loss of that privately held water would be catastrophic for the local economy. Mr. Corbin, representing a ski area in the second nicest part of the country, I wonder if you could tell us what impact this would have on the resorts in your ski area.
Thank you, Mr. Chairman. I appreciate it. And I have worked in Tahoe as well as the Rockies, so I view them both quite fondly, let me say.
Why in the world would you go to the Rockies? Have you no ambition?
I'd been in the Rockies and then worked at North Star, sir. If we were to lose our water rights and literally use the use of that water, we would be very severely impacted, both operationally and financially, as I alluded to earlier. It is very key for us to make sure that we have adequate snow in the opening of the season, for example, Christmas holidays, and likewise in the spring season. Our business of offering winter recreation is really one done in 120 days, and if we lose any significant portions of that because we don't have adequate snow, then we would be very severely compromised. Guests would not have a good experience. We might not have an adequate base for people to ski on. We might not then last an adequate number of days to basically cover our sort of fixed cost, if you will. And
so basically what's at stake with the federal government taking these water rights as a condition of special use permits for you to use federal land is the resorts and the economy that they support would be severely impacted, perhaps to the point of closing down?
We would be very severely impacted, yes, sir.
Mr. Parker, what about your operations?
Yes, and I'm going to be specific to Utah here, and you can extrapolate this across the public land west. But if you take Utah as an example, livestock agriculture makes up about 75% of our farm gate sales. Agriculture and food in Utah is a $17.5 billion industry, making up 14% of the state's GDP. It provides 80,000 jobs. This is just Utah. This is one of the 12 public land states. Provides 80,000 jobs and about $2.7 billion in wages. And the foundation of that is sheep and cattle grazing and on the public land. So it would be very problematic to our state's economy.
So, Mr. Porzak, if I wanted to shut down these operations, destroy the economies in the local communities, is there a more effective way of doing that than demanding that the local ski resorts turn over their water rights as a condition of continuing to operate?
We more effective way is just to deny the special use permit. You're effectively doing the same thing. Two practical issues.
Well, essentially, we're giving you the right to continue to operate, but taking away the means of doing so. Is that essentially it?
That's correct. And just one practical matter is that the water rights are valuable assets, and they're collateral for the operation loans for the ski resorts. So you take away that asset, you've destroyed the collateral for that loan and undercut the ability to obtain that loan. The other factor is that, as I mentioned, the ski industry collectively has spent hundreds of millions of dollars to develop these water rights. If they know that the federal government's just going to take those water rights away from them, you've destroyed the incentive for that investment, and that investment is the driving force for that ski area, and then in terms of the local economy.
Okay. Very briefly, turning to Mr. Cruz, all of our water projects have been based, or at least supposed to be based, on the beneficiary pays principle, meaning the federal government will front money, but ultimately the local water users will repay it through the water that's purchased. The DeFazio bill obviously is simply grants by federal taxpayers to local water users. Is there a better way of running, of providing the programs financially?
Yeah, I think if you're going to do it, surely the beneficiary should pay. In programs like that, the wells are drilled, and in perpetuity, those wells get to be maintained in that area.
Great.
Ideally, you would have those.
Hold that thought. I'll get back to you. My time's out. Ms. Napolitano.
Thank you, Mr. Chairman. Well, Mr. Willardson, why is the federal role in drought planning important?
Well, as I mentioned, the Bureau of Reclamation controls a lot of water in the West. This bill also provides it with authority to provide help to communities that cannot otherwise help themselves, as well as to provide for assistance to Indian tribes. Under the Drought Planning Authority, that's helped Arizona develop its drought plan, as well as the state of New Mexico and the state of Hawaii. They've also assisted the Hopis, the Navajos, the Zunis, and also the Wallapai in Arizona in the Southwest in development of drought plans. Because of the situation with the Bureau of Reclamation, and as you're intimately familiar in the state of California, with the coordinated operation of the State Water Project and the Central Valley Project, there are limitations on the ability of the Bureau to move water move non-project water. And that authority is also provided through this bill. And one other important fact is this legislation exempts those kinds of contracts from restrictions of the Reclamation Reform Act with respect to acreage, and it does require that water provided by the Bureau be repaid with interest, including a portion of the capital costs.
Would you explain briefly, please, because my time is running out, is what would happen, what would be the impact on states? California is a donor state. We get more taxes than we get back. That said, if the Drought Relief Act was not reauthorized?
I think you'd see a very limited ability for the Bureau of Reclamation to participate in state drought planning and response activities. And that would have a significant impact, primarily on those small and local communities and disadvantaged communities.
Oh. Do you have any comment as to what some of the states are currently planning, the western states, to effectively look at how drought is going to be affecting, since we are running into drought cycles?
There are a number of things that the states are trying to do. Obviously, conservation and more efficient use is key to any of our water issues. Also, the development of other storage alternatives, groundwater management. They're trying to diversify their portfolios, water reuse and recycling. Desalinization is something that California and Texas have goals to provide water. So there are many different areas on both the supply and the demand side that impact us not only in drought, but obviously in trying to increase the reliability of future supplies.
Thank you. And there's some concerns as to the infrastructure itself. It's estimated that there are 22 water main breaks a day, which lose as much water as we normally would use.
Infrastructure and aging infrastructure is a huge challenge in the West
Right.
and elsewhere.
Mr. Corbin, we understand the Forest Service is in the process of developing, or was in the process of developing, a new directive to be released this fall. But what is the urgency of this or moving this legislation now? And why not work with the Forest Service to solve the issue administratively? And I say that because I've had issues with some of my transportation folks, with some of my water agencies, and I work with the administration, the agencies, bring them to the table and say, okay, sit down and try to figure it out and let us know where we can help. But certainly, as much as we can, stay out of their way.
Right. I think it's urgent because indeed this process of rulemaking has been going on for some time, and in the course of that we have previously seen proposed rules that indeed have been I think very harsh with respect to our industry. We have previously offered compromise to the Forest Service, suggesting that indeed if the stated goal is to protect water for use in the permit
This is
areas.
before or after the directive was put out?
This compromise was proposed this past summer, following the 2012 directive, yes. And it was a compromise suggesting that the water could be, in effect, protected for use within the permit areas simply by going ahead and having the permittees recognize that we would provide water if it were necessary for some action we requested approval of, and subsequently, if we were to sell and transfer our permit, that we would offer it indeed to the subsequent transferee, so it would stay with the ski area. If that transferee did not want the water, we'd offer it to the local government. If not them, the Forest Service. So we've already suggested a compromise.
Thank you. My time's run out. I'll look for a second round.
Great, thank you. Mr. Tipton.
Thank you, Mr. Chairman, and I think what I'd like to start out with is, Mr. Wilderson, I know you were in to be able to testify on H.R. 3176, but since you are with the Western States Water Council, maybe briefly could you say, are you supportive of the Water Rights Act bill that we have?
The council has not addressed the bill or taken a position, but I can tell you on my reading that it is very consistent with our long-term support for protecting state-granted private property rights, and I would expect that we will be sending a letter in support of the legislation for the record. I'd also note that we are working with the federal agencies and what we call our federal agency support team, including the Forest Service, to identify potential needs of the federal agencies and how those needs can be met within state law.
Great. Well, I truly appreciate your support for state rights and private property rights, and I'd like to follow up a little bit in terms of the question of my good friend, the ranking member's question in regards to the urgency of being able to pass this legislation and to be able to have it move forward. And Mr. Corbin, Mr. Porzak, perhaps you'd like to be able to address this. Does it disturb you? Well, first of all, let's go, Mr. Porzak, to your point. Mr. Corbin, I think you addressed it as well. You've invested millions of dollars developing, paying for water rights. That's a balance sheet item for you, I think, that you noted. Is that correct?
That's correct.
Does it disturb you that, as you noted, Mr. Porzak, there's been no authority granted by the Congress of the United States, but we have an agency through a rulemaking process that is trying to take your private property? Does that speak to you of the urgency?
It absolutely does, and it creates great uncertainty, and great uncertainty inhibits investment.
You know, and I know when we're looking at some of the bureaucracy here in Washington, you know, it mystifies them. When we're talking about a balance sheet item, you seem to indicate that there's some actual value with water. Is that correct?
And the Forest Service has admitted that. That they see enormous value, and that's the principal reason they want control over that value.
You know, with the proposed rule that they put forward that was only slapped down because they did not follow their own administrative procedures initially to be able to come forward with, what is the Forest Service going to offer you for this valuable resource that you've invested money in and paid for?
They've offered nothing.
Nothing. That speaks to the urgency, really, of legislation of Congress acting on behalf of private property rights and Western water rights, don't you think?
Absolutely.
Great. Do you have any insights, Mr. Porzak, why you noted 20 years this goes back, which I think speaks to the urgency? It's Groundhog Day every day for the Forest Service. They just keep doing the same thing over and over again in terms of overreach. What do you suppose, why do they continue to try and pursue your water rights?
They've actually, one of the principal attorneys for the Forest Service has written a law review article, which is a roadmap to exactly what they're doing. And they tried in the U.S. Supreme Court, U.S. v. New Mexico, and lost there to get the right to this water under Federal Reserve rights. They've tried in the state Supreme Courts, and they lost in that venue as well. And so now the strategy is to use their permitting authority as an end run around a state water law to basically obtain those water rights for free. That's
So
always been their game plan.
ignore state water law, ignore Congress, just write a rule.
Yes, and there's always been a federal deference to state water laws.
Right.
And that's particularly important throughout the West because so much water arises on the Forest Service or federal lands. And that's the issue that we face where it's basically an end run around, as I mentioned, to that state water law.
You know, we're talking about the U.S. Forest Service. Do you see any other federal agencies that are going to try and pursue these policies as well?
In your area, the Club 20, which you're familiar with, that question was put to the regional head of the BLM. And they asked, it was in May of 2012, what they thought about the Forest Service efforts. And they announced at that public meeting that what they thought what the Forest Service was doing was great, and if they succeeded, they were going to do the same. And as a result of that, Club 20 passed its policy in May of 2012, opposing those efforts by all federal agencies.
So the people don't want it, the state doesn't want it, the private property owners don't want this, but the federal government, the BLM, the Forest Service, perhaps others are going to continue a policy of taking.
That's correct.
Right. With that, I yield back.
Mr. Huffman.
Thank you, Mr. Chair, and thanks to the witnesses for being here and testifying. I am struck by some interesting contradictions in the testimony that we've heard today, and we've heard some very passionate testimony about deferring to state water law, a proposition I generally agree with. But we also heard some testimony on the issue of Western drought planning and drought relief, that we should simply clear away environmental obstacles to accessing water and leave more to the private sector and to market forces rather than becoming more dependent on public dollars. Well, if we're to listen to this side of the table and defer to state water law, the state of California says all water belongs to the people, that it is not a public commodity that can just be bought and traded and moved around without regard for the multiple beneficial uses that have to be balanced. And so there's an interesting contradiction that emerges on these complex issues. And I guess I would say nothing's quite as simple as it sometimes seems in these type of hearings. I'd practiced enough water law in my career to know that these are very complicated issues. And I respect the testimony that we've heard from the ski industry and others. I want to understand this issue better. But I also know that we're hearing all kinds of legal terms of art and legal theories and legal issues about takings being discussed, and we have only one side of the story represented. You may be right, all right, but I'm having a hard time sorting it out and understanding the merits of what I'm hearing because we don't have anyone from the Forest Service here to explain. I hear a lot of concerns and anxieties about what might happen if the policy goes in a certain direction, but I haven't heard anybody say that their snowmaking water has been actually taken away from them, that they're not able to make snow with it, or maybe that they wouldn't even be able to make it under this policy change. So there's a lot of questions I would love to ask of the folks who actually are being accused of these things, but they're not here. And there's a lot of questions I'd like to ask, technical, legal, policy questions to folks like CRS, which would be a wonderful resource to have in the room. They're not here either because we're in the middle of this absurd government shutdown. So I appreciate that we've scratched the surface of some interesting things today, but I just want to also express my frustration that we haven't been able to go beyond a pretty selective piece of that surface by virtue of the limitations that I've just discussed. And I hope perhaps the next time we discuss it, I'm happy to continue the discussion, that we can have a more complete set of facts before us. Thanks, Mr.
Well, if
Chair.
the
I'll yield
gentleman will
back.
yield, I just want to assure him that the U.S. Forest Service informed the subcommittee prior to the shutdown that it would not be able to testify on this bill. It was not willing to testify on this bill because the new directive was being reviewed by the OMB, and that they were embargoed to comment on it.
And
So that
reclaiming my
has
time,
nothing to
Mr.
do.
Chair, if I might, you know, I guess I would suggest that maybe instead of just leaving it at that and vilifying them for the problem they had and being unable to testify, work with them. Why does everything have to be so adversarial with the Forest Service and these other agencies? Find a time that works for them when they're not subject to that constraint. Get them in here so we can have a complete discussion.
If the gentleman will yield again, I would also point out that the minority had the opportunity to name a witness to this panel for this bill and did not.
Well, we have the same government shutdown problems that you do right now in getting witnesses here. In fact.
Mr. Gosar.
You have a gentleman who wants to.
If I might respond to two issues that you raised. One is, as one who's specialized in Western water law for 40 years now, one thing I recognize is that each of the Western states are different. And while they have common water principles, they are very different. And that's why it's so important to defer to that state water law, because what may work in California might not work in Colorado or Utah or other states. The second issue is that when you do question the Forest Service, one question that I would ask them is that they say they want to preserve this water for that ski area or for the municipality or whatnot, but yet when the ski industry and the municipal interests ask them to agree to limit, if they took the water right, to limit it to the use to which it was previously put. And they absolutely refused to do that. They wanted the ability to change the water and to determine how much was truly needed for a ski use or a municipal use, and then be free to use the rest of that water for another purpose. I would challenge them on that.
Mr. Tipton, we're still on your time.
Thank you, Mr. Chair. I would just say I hope we can get a chance to hear from them, and it's a discussion I'd be happy to continue if we can get all the parties around the table to actually have it in the right way. Thank you, Mr. Chair. I'll yield back.
And in Utah, it's interesting, there's a couple of points that I think are important. One is, by statute, the state of Utah has said those water rights that are related to livestock are appurtenant to the land. So they can't be transferred outside of that grazing allotment. The second part that I think is important is, it just left me, but
Mr. Evans' time is about to expire. We'll go to Mr. Gosar, and perhaps you can continue it there. Yes, you'll start at a new 5, that's
Thanks,
correct.
Mr. Chair.
Thank you. I think the last two people asking questions recalibrated mine. So, Mr. Corbin, what kind of financial aspect can you quantify for me in legal fees you spend to validate your water rights? What kind of money do you spend to validate those rights from the industry?
For the industry?
For the industry.
I honestly couldn't tell you. I know that we, as a ski company, made a contribution to NSAA to participate in the lawsuit that occurred last year. I could not tell you off the top of my head how much we individually contributed or what the legal fees incurred by NSAA were in that lawsuit last year. I can tell you, in any litigation we're involved in, they are substantial.
I would like to quantify that. I would like that question answered. I would like you to go back into your records and quantify that for me. For you, Mr. Parker, how about you? Can you quantify legally what it cost you, let's just say over the last 20 years, and break it down in those areas? How much it cost you to legitimize your water claims?
this is a broad area because there's continual challenges legally in Utah that are related to access to the land. And that access to the land is basically the access to the water. And so you've got to almost lump those together, because as the federal agencies reduce livestock numbers, let's say an allotment has 300 head of cattle that use the water on there, and it's cut to 150, the Forest Service gains de facto water for 150 cattle because they're only half of the number they're drinking now. Even without going through a court action, they gain water rights because of an action that reduces cattle numbers on it. Stock producers and the agencies are at legal loggerheads. It's almost a continual battle. But the problem is we know that the deep pockets of the federal government are pretty tough to beat when you're a rancher with a...
And that's where I'm after. You know, the whole portal in the western states is if it doesn't have the water, you don't have a right. There is no access for that. So there's a purpose of where I'm coming back to. So, Mr. Porzak, from your legal opinion and from law over the last 40 years, are there some remedies, are there some opportunities for the industries that are dictated by this water usage to be compensated for their plight versus the federal government?
You cannot compensate. Water is a threshold and indispensable commodity. It's why it's often difficult to settle water cases, because it's not a traditional business transaction where you can just compensate people with dollars and cents. You can't do without the water. If you don't have the water for the municipal providers, you can't serve the residents. If you don't have the water for the ski industry, you can't make snow, you can't provide the domestic requirements and all the other uses. So it's so indispensable that there is no other alternative.
So in regards to, you know, the private industry and the segment that are dependent upon this versus as you quantified it, you know, the deep pockets of the federal government, wouldn't something like equal access to justice, shouldn't that have some application for those that are egregiously harmed by the federal government? Shouldn't there be some type of compensation for an egregious action by the federal government over states and individuals?
There should be, but that's not what the ski industry or the municipal providers are asking for. They're just asking...
Well, I'm well aware that's not what they're asking. The problem is I've been sitting here for 2 years and I'm a dentist impersonating a politician, and there's a core problem here, is that we see radical environmental groups, and we see the federal government chastising over and over and over and over again, borrowing from the federal government's power of the purse to manipulate and negate your ability to defend yourself. So to me, I think that there's got to be some mechanism here, whether it be the equal access to justice funding that is equivocal in funding to your needs. I see you want to talk.
Yeah, generally, ranchers don't have access to the Equal Access to Justice Act because we're not claiming something is in violation of the law in these circumstances. You have to find the agency at fault in some way violating the federal law, and this may rise to that level.
But that's what they're doing. My whole point is they're violating the federal law because there is no federal law that allows this jurisdiction. That's my whole point. I'm trying to live outside the box. My time's expired.
Thank you, Mr. Stewart.
Thank you, Mr. Chairman, for holding this hearing. To the witnesses, thank you for coming. I know that it's inconvenient for you, some of you. It's expensive. You have other things to do. Thanks for being here with us today. Thanks for the service that you give to your country. If you don't mind, I'm going to spend a little time with you, Mr. Parker, both of us coming from Utah, and we've known each other for a little time. I look at you and I think, okay, here's a guy who maybe has spent a little time on a horse, knows a little bit about ranching, knows a little bit about farming. I want you to know that I do as well. I grew up farming and ranching. We still have both my family farm and my in-laws have a ranch, and it's deep in our blood, and we appreciate that lifestyle. I mean, it is nothing more American than the family farm or the family ranch, and it's something that we want to protect. Mr. Parker, would you consider yourself an expert on, ranching and farming concerns?
I've been involved in ranching since I was born, yeah. Cattle and sheep ranching, yes, sir.
Well, and you represent a fairly large organization, as I understand, right?
We do 6 million member families in the United States that I'm speaking for today.
6 million. That's a substantial number.
Yes.
And I appreciate that. It seems to me, as I said, that you can speak with some authority then about farming and ranching concerns. And I'd like to go back to your opening statement, if I could, something that you mentioned briefly, but I think it's worth coming back to. And that is your telling of what happened out in Tooele County, which is a fairly rural county in Utah. It's west of Salt Lake. It's a county that I represent, by the way. And you go back a few years, 2012, where we had agents from the Forest Service who were denying ranchers and farmers grazing permits unless they agreed to relinquish their private livestock water rights. Look, that to me is just unheard of, and it's egregious to think of the impacts that could have on these, what are almost every case, family farms and family ranches. And I just wondered if you would elaborate on that and maybe just ask, have you ever heard or seen an example of such what I consider an abuse of power?
This is as far as I've seen it, as aggressive as I've seen it based on the livestock industry. I think I want to start by noting that, like the ski industry, water is part of the balance sheet for livestock producers as well. It's part of the asset base that they borrow against. For that group in Tooele County, they initially were asked to sign a change of use application, which would have transferred the right to use that as livestock water to the federal agency, and then they would determine what they wanted to use it for. That's what a change of use application would allow. So they would turn over their ability to maintain that as livestock water on that allotment. The Forest Service objected and said, well, we made a mistake. We only wanted them to sign a joint ownership agreement. And we really didn't mean that they wouldn't be able to use their grazing allotment. Well, you know, that's after the cow's out of the gate, so to speak. And either way you cut it, that's a diminishment or a relinquishment of value and of a right that's granted under the sovereign rights of the state of Utah through the state engineer. It's a taking. There's no question about it.
There's no question. I mean, I may own my home, but if someone demands joint ownership agreement of my home, that's a substantial reduction of my rights and private property. Can you tell us very quickly, how was that resolved? What was the outcome of that?
The regional forester intervened and said, you know, we really didn't mean to go there, and so they've kind of backed away from it at this point. But my view is what happens with the ski industry will be a telltale sign of how much further this creep could get into the livestock industry. Livestock water are across the state of Utah, the second most arid state in the nation. If we don't have that broadly dispersed water for those livestock to graze out there on those rangelands, the grazing value is gone, as is the water value.
Well, and so in this case, maybe they backed off a little, although they haven't backed off entirely on this. It hasn't been closed. But we know that there's instances in Nevada, for example, where BLM and Forest Service agents ended up, some of them in criminal charges and actually going to jail for
in the Hage case, yes, absolutely. Yeah. They overfiled on their water. It went to court. The Supreme Court wouldn't hear it because they said it isn't right. But yes, that's where we've been.
That's exactly right. And so I see my time is up, but just very quickly, Mr. Chairman, look, when you have federal agents that are acting in direct conflict of the law, and they're doing what I consider extorting something as precious as water rights out of private citizens, well, how would we expect those citizens to react? How would we expect them not to have some, to have this?
We'll take that as a rhetorical question, but
yes,
there has been a request for a second round, so we'll get back to that in just
thank
a few
you, Mr.
minutes.
Chairman. Appreciate it. Thank you, Mr. Chairman.
And I'd like to pick up on that very point with Mr. Parker, Mr. Porzak. Are we seeing an adversarial relationship begin to develop between this government and the people? and particularly between the U.S. Forest Service and the users of our public lands. I raise that point because I'm getting increasingly frantic complaints throughout my district of abusive behavior, most recently with the shutdown. Concessionaires who own their own shops, who own their own businesses, literally being forced to close their doors solely because they are leasing land from the federal government. Now, in the 17 shutdowns that have occurred over the past 37 years, this has never happened before. It seems that the U.S. Forest Service is going out of its way to make life difficult for people, to inconvenience people, and almost seem to be reversing the entire original purpose of the Forest Service, which Gifford Pinchot described as being managing the public lands for the greatest good for the greatest number in the long run. Are we seeing a fundamental change in this relationship?
The Forest Service and the ski industry, as Mr. Corbin pointed out, have always had a great working relationship. They've truly worked as partners on many issues. Where the line got drawn, though, was with respect to the takings of their water rights. That was the one time that the ski industry turned around and actually initiated a lawsuit against the Forest Service. It's clear on this issue a wedge has really been driven by the administration.
So this is unprecedented, and it is a fundamental shift in the relationships that have previously existed between the government and the people.
Yes, Mr. Chairman.
Mr. Chairman, from a livestock and agriculture standpoint, this is timber as well. If you go back to the 1960 Multiple Use Sustained Yield Act, there was a right granted to do certain things on the public land under that multiple use banner. FLPMA changed that, and everything now is based on permitting, and those permits can be changed based on the whims of the either Washington, D.C. or the agents out there on the ground. So yes, we've seen a much more adversarial relationship because we've changed from a right to a permit, and those permits can basically go all over the place based on whatever the politics of the day are.
Mr. Corbin, I'm not going to put you in that hot seat, but I have talked to a number of operators over the years who tell me they are simply scared to death of giving candid answers because of their fear of retaliatory actions by the Forest Service. So I will excuse you from being placed in that position. Mr. Cruz, on to the drought relief program. In your view, are the authorities provided under the program narrowly tailored toward the purpose of drought relief? Is your microphone on?
About that. There are too many provisions there that are unreimbursed. The bulk of the money does go to well drilling, but contingency planning and transport and all of these other provisions that are there don't get reimbursed by the beneficiary of the program. And I think, in essence, the approach is wrong.
Well, are there also expenditures in this other than drought relief in the narrow sense?
There's drought relief, there's solar panel, there's desalination. There are program choices that don't necessarily make a lot of sense.
Mr. Willardson, I've got two basic propositions. The first is that cheaper water is better than more expensive water, and that more water is better than less water. If we can agree on these propositions, then I think we can also agree that the entire purpose of our water policy is to protect against droughts. In other words, to store water during wet years in order to have it in dry years, to move it from wet areas to dry areas. And to assure that in times of drought, there's plenty to go around. Doesn't that mean we should be building more storage?
I agree with your premises, and also I would point out that in 1995, I believe, with the Western Water Policy Review Commission, that the comments from the states all included storage as a solution to the problems that they face. I would also point out, being a quasi-economist, that in Utah we've been criticized for having low water rates. Well, in the Salt Lake Valley, we're at the base of the mountain, which is fed by snowpack. There's very little distribution. There is very little treatment required, and subsequently, the water is cheap. Now, does that mean we should artificially increase the price above what it is for production to encourage conservation? The state has set a goal of 25% reduction in use, but it's through other areas besides increasing
Great.
price.
Thank you. My time's expired, Mr. Napolitano.
Thank you, Mr. Chairman. Mr. Corbin, in April this year, nearly 108 ski resorts in 24 of those states sent a letter of support on climate change, or of climate change plan. Are the resorts concerned about the impact of climate change and drought on the water resources available to the ski resorts, and how does this affect your business? And as a follow-up to that would be, what do you think the federal role in helping to deal with those two issues?
Indeed, we are very concerned about climate change, or certainly the ongoing droughts that we've been experiencing recently in the West. As I said, water is kind of existential to our business. Without the water, we're not in business. So to the degree that climate change, increasing temperatures, those sorts of things affect us, the desire on our own part to very carefully manage, conserve, optimize the use of our own water that we have obtained is very critical to us. So we believe we're incented perhaps more than anyone for reasons that are both altruistic and economic to preserve that water and use it wisely.
Thank you. There's so many questions that I would have, and I agree with Mr. Jared Blumenfeld, or Huffman rather, that there are many things that we cannot ask because the people are not here to ask. And Mr. Chair, my staff was only given 6 business days to find a witness, so it's a little hard, especially with a shutdown, to be able to ensure that we have adequate representation. But I don't disagree on 3176. I just think we need to have more input and more information to be able to make a more informed decision, because we are here, it's 3189, sorry, that our role is to ensure that whatever law is passed, that whatever we look at, whatever input we have, that it is good for people, that is the people that we represent. That should be our #1 priority. Secondly, that it is fair for the people, that they have a voice. We are supposed to be their voice. And also, the last one, and I consider that just as important, is that it's good for business and it's good for the economy, because without that, the people will suffer. So with all that, we need to continue to ensure that we have all of the parties represented, that we have the voices of those that sometimes can't speak for themselves, they can't afford attorneys, they don't have the ability to come in and say to Congress, you need to help us, whether it's financially or economically, viably, whatever. So I would suggest that we continue to have conversations and be able to figure out whether this can be resolved administratively with our help or without our help, and that we understand that our responsibility is to all of you as well as to the people that we all represent, and that we continue to find solutions that don't include spending an inordinate amount of money in attorney fees. So with that, Mr. Chair, I yield back.
And I would remind the gentlelady that the notice was the same as the minority party used to give the majority party when the minority was the majority and the majority was the minority. Chair recognizes Mr. Tipton.
Thank you, Mr. Chairman. Just a couple of follow-up questions. Mr. Parker, when you were commenting about permits can be changed on a whim, if I wrote down your comment correctly, effectively what you're saying is, correct me if I'm in error, but you're worried that once a rule is put into place, they can also change it. Does that speak to the importance of the Water Rights Protection Act?
That's absolutely right. In fact, one of the big challenges in the Hage case that Mr. Stewart brought up was whether or not the federal government could in fact stop access to their water. The federal court in Nevada and the district Court of Appeals in Washington, D.C. both agreed that there is a right of access to those water rights, those livestock water rights.
And I appreciate that. And Mr. Porzak, maybe you'd like to get in on this as well, because we've talked about ski areas. We know the economic importance that Mr. Corbin has pointed out, certainly in my district, and Mr. Polis's district, who is a co-sponsor of this legislation as well. But you'd spoken to the point that this is far more than just a ski area issue. You'd mentioned municipal water grazing rights that Mr. Parker can certainly speak to. Mr. Amodei had to step out, but we've heard of water rights being taken by the Forest Service down in the state of Nevada as a condition of permit. When we're talking about the municipal water that we're dealing with in Colorado, is this a real threat? And again, why do you suppose the federal government, the Forest Service, is trying to pursue this taking?
It's control over a resource that's indispensable and enormously valuable. And they've made it clear that they want to have the control so that they can decide how that water is allocated and used.
Right.
And it's time is of the essence on this issue to avoid future litigation.
So we can settle it once and for all to be able to protect your private property rights. We don't have to worry about rules being rewritten. To use your quote, going back 20 years, this is not a new issue. It's time that we settle it, and this is a good piece of legislation to be able to accomplish that.
That's correct. And that's why we're so supportive of this legislation.
Thank you. Mr.
And
Parker?
the point I wanted to add to this is the states do allow, Utah does allow the federal government ownership of water. They just have to go through the same process as anybody else. They have to step up and show that they're going to put it to beneficial use. They have to apply like anybody else. And if they're taking a water right that belongs to somebody else, they have to pay for it. What in the world's wrong with that?
You know, and I believe that's accurate in Colorado as well. We're just not going to allow the federal government to be able to put themselves in first position at the expense of our ski areas, at the expense of our farm and ranch communities, at the expense of our municipalities. They have to play by the same rules as the rest of us. Thank you, gentlemen. I appreciate your testimony here today. And we do look forward to the Forest Service coming up and trying to express why in the world they believe they have the right to be able to take private property. Thank you, and with that, I yield back, Mr. Chairman.
Thank you. Mr. Stewart's next. Mr. Stewart, if I could request, if you've got any questions for Mr. Porzak, could you make those first? He's going to have to get out of here to the airport.
Actually, I don't,
Okay,
Mr.
then,
Chairman, and I'll be...
Mr. Porzak, I want to thank you so much for being here and welcome you to leave at your discretion.
Thank you very much.
I want to know how come he can go home and we don't get to.
I got the last seat on this airplane today.
Mr. Stewart.
Yes, I'm going to be very brief. You all have been patient with us as we delayed for the vote, and it's getting late, and so I won't take but a few minutes. But I want to pursue what Mr. Tipton was saying and maybe draw some conclusions from it. Let's, for the moment, give the Forest Service or BLM agents the benefit of the doubt. Let's suppose that they have reasons for some of the things that they've done, or at least that they had some objective that they were trying to achieve. And I would ask maybe Mr. Corbin or again my friend Mr. Parker, you know, have they explained to you what it is that they're hoping? Why is it that they would exert these rights when it would be contrary to tradition and law?
The argument that they've made from a livestock standpoint is they suggest that that's the way they can assure that it will be there in the future to maintain their multiple use obligation and allow grazing. But we've already made that happen in Utah under state statute. Yep. We've made livestock water rights pertinent to the land.
I think that's exactly right. Their desire to tie that water to the land. And I'm going to come back to that. Mr. Corbin, did you want to add to that?
I would agree, and the same rationale has been given to us, that the stated purpose is to have the water available for the special use permit and the ski area per se. But as has been testified here already, in the rule that was proposed in 2012, there really wasn't such a restriction. It was indeed contemplated that uses might be other than skiing and outside of our permit areas for other purposes, whether that's aquatic systems elsewhere or not.
Whatever it might be.
Could be anything.
That's
yes.
right. Which brings me to the point I'd like to make on that, and that is, while they wanted to ensure that the land and the water were tied so that it would continue to be used for the purpose that it was being used, they were afraid essentially that the water rights would be sold downstream for other uses or for some other cause. But we asked, not myself, I wasn't in Congress at the time, but the Congress asked the chief if he had any examples, even one, of that occurring. And this was several years ago, and his answer was no. We don't have a single occurrence where that has been actually what took place. And I'm wondering, in the ensuing 2 or 3 years since then, are either you aware of any example of that occurring?
In my experience, no, sir. I'm not aware of any ski area that's essentially stripped itself of its water and sold it.
Of course not.
As
of course they
it
wouldn't
would
do that.
severely hamper your ongoing enterprise. So
Yeah.
there's no real reason to strip your water off
No
of your ski area.
self-interest of you doing that. Mr. Parker, do you?
And if you take where livestock water is across Utah in particular, it's been developed out there across the landscape, and it's an arid landscape. And a lot of them are just troughs where seeps have been run into it for water for livestock and wildlife. It would be impossible to be able to transfer that dispersed water out there across the Utah landscape, put it into a pipe and send it to some municipality.
Yeah.
It can't happen.
Practically.
The best use of it is livestock water for the economic opportunities that it affords rural Utah.
Yeah. Well, and so I started out my questions to you by saying, let's give the agents the benefit of the doubt, try and understand why they're doing this, but their own reason, their justification, it's chasing a ghost. I mean, they're trying to solve a problem that doesn't exist. What they're trying to do is to preclude a problem that, by their own admission, does not exist.
If you look at the findings in the Hage case, particularly when the federal government, the agents filed a trespass suit against the family, it's not, the agencies are strong-arming these individuals out of being able to clean their ditches, out of using their water right. These are federal agents that by court were fined for illegal activities against those ranching families. Very few of them have the financial wherewithal to do this. The Hages did, and they found a pretty tough treading to go through the court system.
Yeah. Well, thank you. Again, to all of the witnesses, you've helped me make some important points with your experience. And Mr. Chairman, I yield back.
I'd like to thank our witnesses for their valuable testimony today, and again for their patience on our late start. Members of the subcommittee may have additional questions, and we'd ask that you respond to those in writing. The hearing record will be open for 10 business days to receive those responses. And if there's no further business, without objection, the subcommittee stands adjourned. Okay, thank you. You want to go up right now?
Yeah, sure.
Okay, good.
Thanks, Tom.
Oh, pleasure.
Stick around.
Good to see you. That's all I got on your agenda to come speak to our in November. Okay, that's a Friday night.
Yeah.
And we want you to be there for the awarding of the Leopold Award and, some of that kind of stuff.
I may not be able to stay. I've got to speak at a Salvation Army fundraiser that night. But I'm going to be there I think it's at 4 o'clock, and I'm hoping to stay until...
Appreciate your testimony.
I'm going to stay as long as I can. I'll tell you that.
It'd be fun to have you there with us, but understand when you're home, it keeps you busy.
The problem is that we're never home.